Senator Carson, you should be all set.
Thank you, Aaron. And good afternoon, everyone, and welcome. I am Senator Sharon Carson from District 14. Today, we will be holding a meeting of the Senate Judiciary Committee. Before we'll get started, I'll read through a checklist to ensure that the meeting that we are holding is in compliance with the right to know law. As chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the Governor's Emergency Order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the Governor's Emergency Order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selective legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. In the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. 6, finally, let's start the meeting by taking a roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during the meeting, which is required under the right to know law. I will call the roll. Senator Whitley.
Good afternoon. This is Senator Becky Whitley. I'm at my home in Hopkinton. I'm alone in the room, but my husband is in the house.
Thank you. Senator Gannon.
Senator Bill Gannon in sunny Sandown, not so sunny today. My wife and daughter are upstairs. I'm in my downstairs law office.
Thank you. Senator French.
Harold French, Senator District 7, broadcasting once again live from the offices I share with Attorney Sullivan in Concord. He is in the room.
Thank you. Senator Khan.
Good afternoon. Jay Khan in Keene, at home and alone.
Thank you. And
It's
I'm
beautiful here, by the way, Senator Gannon.
Sorry.
Just thinking, look west.
Look west, young man.
And I am Senator Sharon Carson. I am at my home in Londonderry and my daughter is in the room with me. So we're going to get started today by opening the public hearing on House Bill 139 and call the prime sponsor, Representative Yokela.
Thank you, Madam Chair and Senate Judiciary Committee. I am here today to introduce HB 139. And the problem we have is that in divorce proceedings, a lot of people are representing themselves. And there are guidelines in court that you need to disclose your evidence 10 days prior to the hearing. However, that requirement may be waived by the judge. And so what this bill is trying to do is set a floor, whereas if the judge waives that requirement, that if it's waived for evidence submitted not less than 5 days prior to the hearing, then the opposing party would have the option to continue the hearing so that they have time to prepare for that evidence. And there are a couple of options where if the judge says that the evidence is de minimis, or that the evidence was not available to the party submitting the evidence 5 days prior to the hearing, that would not be grounds for a continuance. And the judges wanted to have some flexibility with how long the continuation of the hearing would be set out. So it's set to 90 days instead of just a 30-day continuance because of their need for flexibility in that issue. And so there's also the option for if a judge does declare the evidence is de minimis, then they will need to write that down so that someone would be able to challenge it if they needed to appeal. And so we're just trying to set a floor which says, okay, if you haven't had very much time to look at these evidence, that you have the option to continue and prepare for your case. And so that is generally the gist of this bill, and I'm happy to answer any questions.
Okay, thank you very much, Representative. Senator Gannon has a question.
Hey, Rep, how you doing, kid? Today, kid? He's in my district, so I can be informal. You can be informal with me too. Did you actually have? Were there problems in court with this? When I used to do divorce work a million years ago, the pro se litigants were always the judge bent over backwards for him. Has this been a problem? Is that why you're doing it? People came to you?
So this is actually a bill that has been batted around for a little while and actually was proposed by Representative Itzy from prior years. And he had brought it to my attention. And since he was not running again, he asked if I would take over it. And so they were reaching out to him prior to my tenure in the legislature. Thank you.
Thank you, Representative. Have a great day.
You too.
Okay, are there any further questions for Representative Yokela? Okay, seeing none. Thank you very much, Representative. Next, we're going to go to Richard Head.
Good afternoon, Senator Carson, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. There are several issues about this bill that we just wanted to identify for the committee. There is currently a rule that deals with marking of exhibits, exchange of documents, and prior to a trial. That's in the family court rules. It's Rule 2.21. And it provides that it's generally held 10 to 14 days before a hearing, that you're required to bring exhibits and what you're going to present for evidence in terms of witnesses. It also provides that the parties are required to bring and exchange pretrial statements, financial affidavits, proposed decrees, and if there are minor children involved, child support worksheets, and so on, et cetera. The rule also says, following the pretrial conference, the court shall not accept modifications to the documents presented at the pretrial conference unless the modified documents have been exchanged within a reasonable time before a final hearing, and that the rule shall be strictly enforced. We have some significant concerns about trying to impose a different rule through a legislative action, where we do have a current rule that addresses evidentiary hearings. And we do also have a rules committee that does have both a representative and a senator that sit on the court's rules committee. If there are issues with the rule, the better venue, I would say, is to present it to the rules committee to see if the rule needs to be adjusted. The other aspect of the bill that is presented to you is the requirement that there be a hearing within 90 days if there is a continuance. And that creates substantial problems because right now, depending on the court, you may be looking at more than 90 days in terms of your ability to get a trial Some courts are scheduling the family docket into next year currently, and it also depends on the length and nature of the trial. If you're talking about a 2-hour hearing or trial, or are you talking about a 5 to 7 day trial? If we are required to do it within 90 days, we very well may then have to bump another case and take a case off the docket that's currently scheduled and has been scheduled. So it creates substantial procedural problems for the court in terms of managing a docket and managing how cases are presented. There are instances in which evidence can be presented and does get presented sometimes after a pretrial conference. It is not viewed well by the court, and unless it's relatively de minimis or if not a surprise to the parties, it may not affect the trial date. There are instances in which a piece of evidence is identified after the pretrial, but it is not a surprise to the parties. That should not require a continuance, and really should leave it in the discretion of the trial court judge. So I think with that, I'd be happy to answer any questions, but we do have some significant concerns about the bill as it's presented to you.
Thank you very much for your testimony, Mr. Head. Senator Whitley has a question, and then Senator Gannon.
Thank you, Madam Chair, and thank you for taking my question. So it's really related to how litigants are, approaching the court system. And it seems to me that, this could potentially create some confusion because of the inconsistency of the evidentiary requirements. Would you agree with that?
Absolutely. A huge confusion, I think.
Thank you.
Thank you. Senator Gannon?
Sort of a follow-up on that lines. So it's like a balancing test. The closer it gets to the day of the actual trial, if it's like 2 days before, they're going to look at sort of the probative versus prejudicial, for lack of better words. Is it a balancing test as it gets closer for the judge? I think that's what you said.
I think, once you get past the deadline that you were supposed to have filed, getting closer, yes, it could be more problematic, but the court expects the parties to present on the day that the order says that they're supposed to present. If, however, there are, and obviously it happens, and I suspect you've seen it happen, where evidence doesn't get recorded or is not properly identified on a pretrial statement, and then after the final pretrial conference, there's an amendment to it that gets filed. And it has a new piece of evidence. Well, the court does then have to balance what are the issues that are now being added through that piece of evidence. Is it a surprise to the parties? Do the parties, have enough information and enough time to manage it? Or does a party, in fairness to that party, now need more time? So it is a balancing test. I don't think necessarily as you get closer past the pretrial that's the determining factor, because they're really supposed to have it at the pretrial conference.
Thank you.
Senator French?
Thank you, Madam Chair, and thank you, Mr. Head. So did I get you right in saying that the courts would have or could have difficulties rescheduling within 90 days?
Yes, absolutely. Right now, in some courts, especially, again, it depends on the nature of the trial. But if you need to put in a 5-day trial sometime in the next 90 days, you're going to bump another case. But it depends on which docket you're talking about, which court. But some courts are currently scheduling their family cases into next year, depending on how busy that family court docket is. And it's really just a determination of the number of judge hours available and the number of cases pending.
So follow up?
Follow up? Mm-hmm.
Thank you. So if some cases are being delayed now until next year, couldn't this be used if you didn't have that deadline as a delaying tactic by one side or the other?
Absolutely. And I should have mentioned that, but I think some of the other parties on the policy side will be mentioning that if you have an absolute right to a continuance and delay supports your side, it will not surprise you that the rule could be used then to manipulate the party's advantage of gaining delay if there is an absolute statutory requirement of continuance. So certainly that could be an issue.
Thank you.
Are there any further questions for Mr. Head? Okay, seeing none. Thank you very much, Mr. Head.
Thank you.
Next, we're going to go to Mary Kruger.
Thank you, Madam Chair and members of the committee. My name is Mary Kruger. I'm an attorney at New Hampshire Legal Assistance. I primarily practice in the area of family law. We have a domestic violence advocacy project, and we represent survivors of domestic sexual and stalking violence in various family law cases. We are in opposition of this bill and ask this court this committee to vote inexpedient to legislate. I would just reiterate some of the points that Mr. Head made, and would emphasize that under the current court rules, there is a process for pretrial where folks would be required to submit their exhibits ahead of time. If the court doesn't have a pretrial, there's another rule that also provides that those exhibits ought to be submitted within 30 days before the trial. If someone does not follow that rule, the court can exclude that evidence or witness that wasn't disclosed within those timeframes. And that's a real incentive for people to comply with that rule versus this, where there's the opportunity for someone to thwart the rules or this statute in order to delay and get the automatic continuance. Our concern is where we've are quite experienced in representing victims and survivors of a domestic abuse where there's coercive control in operation. The court can often be the last place where that control can be exerted, and that this could be inadvertently used in a way to really delay the process, where sometimes finality is critical in these kinds of cases, especially when there are children involved. So that's the main reason that we would oppose. But I agree that the courts right now are very backed up due to the COVID situation, and have even prior to that difficulty in scheduling final contested hearings, even just a day trial, not even talking about a 5-day trial. So this could really put a lot of pressure on the courts that have already been under a significant amount of pressure, and I think we'll be catching up for quite some time due to the situation with COVID. And I'll take any questions. Thank you.
Thank you very much for your testimony, Ms. Kruger. Are there any questions for Ms. Kruger? Senator Gannon.
Real quick, Ms. Kruger, do they still, as I said before, bend over backwards for a pro se? So if a regular firm's going up against a pro se, would they give them a little more time if they were a little off? If they missed it by a couple days, are they going to be a little easier on them?
Generally, I think the courts are going to be understanding of pro ses or self-represented litigants who don't understand the process. But I do think that if it's along the way, the judges tend to give a lot of reminders. Some judges send out additional, expectations along the way to make sure that people understand the rules. I think that the family division does quite a bit with the case managers in order to help the self-representative litigants. So to the extent that there's an issue, I think by the time you get to trial, if there's that unfair surprise, the court is going to use good judgment around what it's going to exclude versus what seems de minimis. And if it can take a 15-minute break for somebody to review a single document, that may be all that's needed versus a stack of financial documents that someone's requested over and over again. as deliberately withheld to sort of throw a wrench in the works.
Thank you, Attorney Kruger.
Okay, are there any further questions for Ms. Kruger? Okay, seeing none, thank you very much for your testimony, Ms. Kruger. Margaret, are there folks in the waiting room who would like to testify?
If anybody else wishes to testify, if you could virtually raise your hand. I do not see any hands raised.
Okay, thank you very much, Margaret. I am going to close the hearing on House Bill 139. Next, we're going to open the public hearing on House Bill 161 and call the prime sponsor, Representative Yokella.
Hello again, Senator and members of the Judiciary Committee. I am introducing HB 161 to update our child support guidelines. Every 4 years, we have a study that is required by RSA to be performed on our child support guidelines to make sure that they are working as intended and are not out of some range of reasonableness. And our last review was done in 2018, and I emailed you guys a copy of that study just a little while ago so that you can reference it. So this bill is just trying to implement some of those recommendations. Those recommendations included in raising the self-support reserve from 115% to 120% of the federal poverty line, so that people were put less into poverty by their child support, and to update the percentages based on the combined net income of the parents, and to include shared parenting as a part of that calculation. So right now, a lot of the deviations from our current child support guidelines happen when there are shared parenting, which bogs down our courts and is confusing because the parents don't really know what's going to end up happening or what's going to be decided because it's not in statute right now. And so this adds the child support guidelines or shared parenting to the child support guidelines as it was recommended in that study. The study recommended that we use child overnights with a parent of 30% more of the time being the threshold for a shared parenting calculation, where the shared parenting calculation multiplies by 1.5% the amount of supporting of the child that is calculated normally. And that's because when you're spending a significant portion of your time at each parent's household, they really have more things that they need to upkeep to be able to take care. You're not moving stuff back and forth as much as having 2 sets of clothes, 2 sets of toothbrushes, et cetera, et cetera. And so it raises that amount, and then it gives a credit for the amount of time that the child is spending with that parent. And so the math and how that kind of all works out is explained in that report, which I emailed you. And so it's a little bit complicated. I don't want to bore you with it. And so I will be happy to answer any questions on this. Thank you.
Okay, thank you very much for your testimony, Representative. Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Representative, for taking my question. because this looks like a pretty dramatic change, a brand new formula that we're going to use, do you think that this new formula adequately takes into account sort of what's in the best interest of the child?
Yes. Yeah. In addition, that we added some language in the House that said that nothing in this paragraph shall preclude the court from modification of the child support order based on the best interest of the child. So that's actually added into the law. But yes, it's going to help people not going into poverty and being able to get the benefits of both parents when they are capable. And so yes, I do think that it will help in the best interest of the child. Thank you for the question.
Are there any further questions? Senator Khan?
Thank you, Madam Chair. Thank you, Representative, for presenting your bill and taking questions. I wanted to, so we had Senate Bill 16 that we considered at the beginning of the session that covered much the same area. I think many of the people who worked on were at least, there were many informed people who came forward and supported Senate Bill 16. And I'm just wondering, have you had a chance to take a look at that? It established a flat rate. It was 123%. I'm sorry, it's 23%. It was very straightforward. Not being familiar with this before, I questioned it quite a bit, and the folks who came to testify were very consistent across the board with various interests to support it. So I am interested in your thoughts about that report versus, or at least that legislation and that hearing versus the position being taken in your bill.
Thank you for the question. I'm on the Children and Family Law Committee, so we just heard this bill like last week, I believe, or the week before, in my committee. And that SB 16 is relative to alimony, and this is child support. And so those are really two separate things. And the child support is way more complicated, I believe, and how much a child should be supported by their parents, and a flat percentage of 23 or 30% of someone's wages is not, I don't believe would be appropriate. As you can see in the bill, there are a sliding scale of how much of percentage based on how many kids you have, how much money you make, what is the percentage of money that would be spent towards the raising of that child. And so I'm not sure that a flat percentage would work. You know, if you had 4 kids, the percentage would be obviously different than if you had 1 kid. And if you had more money, and then a different percentage of your income would be based on if you had less income. And so all of those types of things come into play. And so the formula and the percentages that are in the bill are the percentages that were recommended by this study, which was a $500,000 study. And we're about to have to do another study in 2020 or 2022, because it's required that we do it every 4 years. And we haven't done anything since the last change, or the last study, which was 2018. And actually our child support formula hasn't been changed dramatically since 2013. 13. And so we are long overdue for an adjustment on that. And so I thank you for the question.
Thank you.
Are there any further questions for Representative Yokela? Okay, seeing none. Thank you very much, Representative. Next, we're going to go to Richard Head.
Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for I can't say it, for the Judicial Branch. There are two things I wanted to identify in this bill. One is actually a very significant concern, which is this bill has no applicability provision. The last time, as the representative said, this has not been changed for a number of years, and it was a 2012 bill when it was last changed. And if you go to that bill, which was Chapter 248 in 2012, it had a very specific applicability provision, which said it shall apply to child support orders issued on or after the effective date of that legislation. This bill, because it does create significant changes to the schedule, in every schedule, there are folks who see it as beneficial and some who see it as harmful. Under the bill as currently written, essentially every currently active child support order could be the subject of a petition for amendment, which could completely inundate the court system. And I apologize, I did not notice that when it was over in the House, so I did not testify to that on the House side. And I did not really see it until it was before this committee. So I did not testify to that issue in the House side, but it does give rise to just huge potential problems in terms of the court management of its docket, because we could get inundated. So we would ask at a minimum that something analogous to the Chapter 248 in the 2012 legislation, that there be an applicability provision that it applies to child support orders issued after the effective date of the bill. And then in 2012, it said as to those that were essentially in effect already, that the old order would remain in effect until the next scheduled review hearing. So that language would be essential for this type of just a huge change to the child support guidelines. We do have a concern, more just an uncertainty as to sort of how it applies. The bill has in the last section, Section 7, a repeal provision, and paragraph Roman 2 would repeal 458C5, which then goes into paragraph 1H2B. And 1H2B is a consideration in considering adjustments as to whether or not the obligor parent has established that equal or approximately equal residential responsibility will result in a reduction of the fixed costs of child rearing incurred by the obligee parent. And we're not quite sure what it means to strike it, because as the bill is written, there's a co-parenting is at a 30% or more level. And the fixed costs could be a consideration. And the issue that arises is, by striking this paragraph, is that no longer something that could be considered by the court in evaluating adjustments to a child support order that would be issued under the schedule. The schedule will likely result in significantly different child support orders than under the current schedule. We do not take a position on the policy of the schedule, but just raise those two concerns and specifically ask that there be an applicability provision added. Thank you, and I'd be happy to take any questions.
Thank you very much for your testimony, Mr. Head. Are there any questions? Senator French and then Senator Khan.
Thank you, Madam Chair. Just a couple of questions. One, is there anywhere in the statute where it reads, or any other amount agreeable to both parties?
If they reach a settlement separately, they can do that. Truthfully, I can't point to you. Hopefully somebody else will be able to, who's testifying after me, give you a section that can give you that. But
It is
Um,
allowable before the courts.
You know, I'm not a child support expert, so I'm hopeful if you don't mind asking the next somebody who follows me, who hopefully has greater family law experience than I do.
And the other question, trying to do the math here, will the judges have access to a math teacher to help them figure it out?
One of the comments was as to how are we going to figure this out, but that wasn't. But we'll figure that out, I guess.
Okay, thank you.
Okay, Senator Khan?
Thank you, Madam Chair. Thank you, Mr. Head, for testifying both bills today. If I want to make sure that I understand your concern about the applicability date, if the rates change, meaning that if the current rates in statute, which are minimal or establish a floor anyway, unless mutually agreed upon, that if that floor drops below what current statute provides, you would expect that there would be a rush to the door to try to revise existing agreements.
I think that's correct, Senator. And what we would be asking for is that there be a controlled review and modification of it, as opposed to everybody who on the effective date sees an advantage filing a petition.
Yes, thank you.
Are there any further questions from Mr. Head? Okay, seeing none, thank you very much.
Thank you.
Okay, next we're going to go to Honey Hastings.
Here we go. Thank you, Senator Carson and members of the Judiciary Committee. I'm a certified family mediator working in both the courts and privately, and a retired family lawyer. I've used the child support guidelines since there first were guidelines in 1988. I oppose House Bill 161, and I've worked with others who see significant problems in the bill. I think others will testify as well. I did email you all my written testimony. I hope you have that. I also sent it to your staffer. If adopted, this legislation would make substantial changes in how the child support guidelines would be applied to at least 37% of divorce and parenting cases. The UNH report said that even now, in the period they studied, they found that there were deviations from the guidelines in 37% of cases. So this formula would certainly be used there and maybe in more. So it could apply to a large number of cases. And this bill has major both substantive and technical problems. So to review them, the definition of shared parenting. This is an entirely new definition in New Hampshire parenting law. It has not been in effect, and I think it's just adding a new definition is problematic in itself. I think that the folks who did this at UNH are probably very good in their field, but they appear to not have really had any substantive input from divorce professionals. When I reached out to some other lawyers and mediators, I would say approximately 90%, maybe more of those that I shared the substance of this bill with opposed it, particularly the 30% of overnights provision. This we see as really problematic, and it's going to it's going to incentivize people to look for more time, even if they've not had the care of the child or have had minimal care of the child. But if they could just get a couple more overnights, they would be up for a substantial change. I'm concerned that the definition doesn't consider the child's best interest or the psychological impact of this fighting for and perhaps getting additional time. Now, the provision that the sponsor mentioned about best interest, it's a good idea, but I don't think it's really enough. It doesn't put best interests of the children first. It says the court can make adjustments for best interest. Under the current law, cases with equal or approximately equal schedules may seek a guidelines adjustment. And again, they have to meet a 3-part test. The test includes 2 provisions that are repealed in the end of this bill. I think we've lived with equal or approximately equal schedules, that concept, that term, as a legal term of art in New Hampshire parenting cases since 2005, when the Parental Rights and Responsibilities Act took effect. This is now an entirely new definition. It's scary as to what that would be. And the 30% of overnights, an overnight could mean pick up the kids after supper at the other parents and drop them at school in the morning. That doesn't involve a lot of the expense. It's not clear. Well, I think that we've worked from 2004 to get rid of terms that connect parenting with time, and have tried to say what parents do is parent. We don't have superior parents and inferior parents. We don't have someone who has custody and someone who doesn't. They're both parents of the child. So we got rid of, in 2005, custody and visitation. Then we got rid of primary residential. Now all that a parenting plan says is, this is the schedule. This is when the child is with one parent. This is when she's with the other parent. To add this time-connected title for people to fight over is a backward step. The elimination of these other terms I've mentioned has had a very positive impact. Parents used to fight to get the title, custody or residential parent or whatever. And now, they don't have that to fight about. If they agree on the schedule, we just call them parents. There's a real risk in domestic violence cases, and you may hear more about this from someone who is more of a specialist in that area, but we're very concerned that where there's been abuse or coercion, that there may be real problems with a push for a shared schedule to get reduced support. This formula is very complicated. I note the question about whether the judges will be given software. I tried to do the formula for the examples in the addendum, and I understand that someone has sent you the report, perhaps it was a sponsor, but it's important that you also read the addendum, because the addendum came with a note from one of the UNH professors that said, sorry, we made mistakes in the arithmetic. So we've redone the examples. It's complicated. I couldn't figure out who was to pay what. And I've been in this line of work since 1982 and with the guidelines since 88. How are self-represented parties going to use it? There's a lack of comprehensible supporting examples. As I indicated, there was this miscalculation, and the addendum examples, most of them, I can only tell for sure. I think the who pays what in one, where they had equal time and equal incomes, and it was clear that it was zero. But I didn't need the formula to understand that. I'm not sure if the formula in the addendum and thus in the bill produces fair results. And I'm not sure if the formula is correct now. Many of us complained when back in 2018 that there was a problem with the math, and it took them, several months or a year to come out with the addendum, and it's still questionable. And I've asked lawyers at Child Support Services about this, and they could not provide an answer. I even sent an email to the professor, and she hasn't answered. Another problem is this doesn't make clear who's paying for what. Childcare, uninsured expenses, health insurance, extracurricular activity. It's just not clear, and that's that's a major problem. I understand from someone who attended the hearing in the House that the House committee considered things that weren't just a matter of good public policy, that in fact, someone there suggested that they should adopt the bill because they had already spent so much money on the UNH report. I don't think that's a good reason if the results are not good and fair in New Hampshire. There are two technical problems. One was the problem that Mr. Head mentioned about the lack of applicability section, and you'll find in my testimony, my written testimony, the wording from 2012. It definitely needs that for all the reasons he said. It also, I think, this bill needs a fiscal note. The reduction in child support in all these cases may mean more parents seeking either state or local aid. There was another bill in the House, killed there, but there was another bill that would have reduced child support, and there was a fiscal note to it, and the language I put here in my testimony. So I think that should be looked at. The informal group that's working to oppose the bill today would be willing to meet over the summer and come back with an alternate proposal for child support in cases where parents have an equal or approximately equal parenting schedule. I ask that you kill this bill and give us a chance to come up for a solution that'll work for New Hampshire families.
Thank you very, very much, Ms. Hastings, for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none. Thank you very much, Ms. Hastings. Okay, next we're going to go to Matthew Hayes.
Thank you.
Good afternoon, Mr. Hayes.
Good afternoon. Members of the Senate Judiciary Committee, on behalf of the Department of Health and Human Services, Bureau of Child Support Services, I thank you for giving me the opportunity to speak about HB 161. My name is Attorney Matthew Hayes. I'm a staff attorney with the Bureau. My testimony is going to pretty much echo a lot of what you already heard from the court's representative, but I'd like to at least state this in terms of the Bureau's concern specifically. Title 4D requires that all states follow federal rules and regulations when establishing and enforcing child support orders. And as part of the Bureau's mission under or mandate under Title 4D, the Bureau provides services to periodically review and possibly bring forward to the court parties' child support orders when either party requests the review pursuant to RSA 458C7. These child support orders are subject to review and modification either 3 years from its effective date or upon petitioning the court at any time based on an alleged substantial change in circumstances. As HB 161 is currently drafted, it does not address whether the proposed changes to the child support guidelines could constitute a substantial change in circumstances for orders that are currently in effect, and does not state whether those changes would be applied prospectively. Without clarifying this, theoretically, any current order would be subject to be brought forward by the department or either party. If HB 161 provided that the changes to the guidelines would not be a basis for a substantial change in circumstances for modification purposes of a current order, then the department wouldn't have to face any significant burdens. However, if the bill were to be applied without providing that any changes are going to be applied prospectively, it would cause a burden on the department. As mentioned, the department assists parties in reviewing their child support orders. Should orders that are already in effect, in other words, not yet eligible for the 3-year review, suddenly become eligible for review under the substantial change in circumstances theory, it could significantly tax the department's resources and would greatly increase the caseload. The department thanks the committee for taking its concerns into consideration, and thank you for giving me this time to speak, and I would be happy to answer any questions.
Thank you very much for your testimony, Mr. Hayes. Are there any questions from the committee? Okay, Senator Khan has a question.
Thank you. I just wanted to understand, you said that the committee would need to get together again soon? Is that, when would you convene the same group that made the recommendations in 2018?
Thank you, Senator, for your question. Are you referring to the periodic 4-year review?
That's right.
I believe we're in the process of, I would have to look, I don't know the answer off the top of my head, Senator. I believe that we are looking for the next, I don't know, I think we're looking for for the next review. We're looking towards getting that review done for the next time period. I can certainly check into that and email you an answer specifically addressing that question.
I would appreciate that. Thank you.
That's not a problem at all. Thank you.
Are there any further questions? Seeing none, thank you, Attorney Hayes. Next, we are going to go to Mary Kruger.
Thank you, Madam Chair and members of the committee. My name is Mary Kruger with New Hampshire Legal Assistance again. We are asking that this committee, we are opposed to this bill and asking that this committee vote inexpedient to legislate. I would second the testimony from Attorney Hastings, and I have similar concerns that were raised by Mr. Head and Mr. Hayes as well about some of the technical issues. There's no doubt that parties and courts can struggle with coming up with a guideline amount where there's equal or approximately equal parenting time. And that is something that we've spent a great deal of time examining, and there may need to be a change. This change, as written, would not accomplish the broad policy goals of meeting the children's best interests for some of the reasons that were already discussed. Additionally, in the report itself, the report recommends that any legislation allow for exceptions when parenting time, and I'm quoting, is addressed to ensure that appropriate safeguards are included in cases with intimate partner violence to guarantee safety for children and the abused parent. And would just reiterate that the court, and unfortunately sometimes the children can be swept in when there is coercive control and domestic abuse involved into that dynamic. And where we have a new concept of shared parenting introduced in the child support statute, that really red flags it for an abuser in a way that could be utilized to disadvantage not only a victim of violence, but also the children as well who need to be protected. So that is a main concern, is changing some of the language that several legislative committees and private stakeholders have worked hard over the years to really encompass the idea of parental rights and responsibilities, equal or approximately equal parenting time, getting rid of words like custody, to really try to embody the idea that the children are at the center of these cases. And our child support statute ought to reflect that as best as it can. It may be that some adjustments need to be made to the table. I look at the lower income, and again, NHLA, we represent people who are at 200% of poverty level or below. So all of our clients are in a low-income population in New Hampshire. And it's a huge jump in this new table to go down to 22% of the net income from what we currently have, which has more of a stepped percentage, starting at 15,000 net income or less of 25.6%. And I'm talking about for the one child. And then it goes up 22% is at the $60,000 level for one child. So there's a huge jump in the numbers. And I don't personally have the time today to analyze how that's going to go, and would encourage this committee to an expedient to legislate, and NHLA and others who've been working together to look at this report and to look at the broader issue of equal and approximately equal parenting time, to work on methodically trying to analyze some of these numbers as to how these guidelines, if changed, would be implemented in New Hampshire and for New Hampshire. And I've had some time to look at Vermont and run some of the calculations there. One striking difference, because Vermont is cited here, and really this, I think, is modeled most closely to what Vermont currently does, is Vermont handles in contested parenting cases the issue of parental rights and responsibilities in a separate hearing first, and decides how parenting time ought to be allocated, and then has a separate hearing, creating really a wall. Maybe it's a psychological wall, but I think a helpful one, to then having a separate hearing to determine what the support will be and who will pay. And that's really what is in the children's best interest, is to try to tease apart the issue of who has to pay what with what do the children need in terms of contact with their parents and meaningful contact. And that those, having that psychological separation is essential for children. And then the last thing I'll say is I did try running through some of these calculations as written, and it is not totally clear as it is written as to what to do when there is equal parenting time as to who pays. So I do think there's some technical issues currently as it is written. I'll anticipate Senator Gannon asked a question about whether parties can agree to a child support order. And Senator Gannon may know that currently under the special circumstances provision in the current statute, the court needs to have several factors in order to allow for an agreement by the parties that they've accounted for certain fixed costs and variable costs in order to make an agreement about any variation from the guideline amount. I think that this current bill as written does remove a couple of those factors, and it does not add any language to allow for an agreement by the parties. I'm not sure if that's the solution to the issue, but I'll just point out that it's not there. So thank you.
Thank you very much for your testimony. Are there any questions for Ms. Kruger? Okay, seeing none, thank you very much. Next, we're going to go to Pamela Kylie.
Good afternoon. Can you hear me okay?
We sure can.
Thank you so much, Madam Chair and members of the committee. For the record, my name is Pamela Kylig, and I am a public policy specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. I'm here in opposition to HB 161, which would drastically alter the child support guidelines in our state. When it comes to calculating child support, the first and foremost consideration should be whether or not the outcome is in the best interest of the child. However, HB 161 shifts the entire focus to a financial incentive. Currently, New Hampshire's child support guidelines do not consider how much time a child spends with each parent. Instead, it is purely income-based, calculated through a child support worksheet, taking into account the financial factors at play for each party. There should be no incentive for someone to ask for or try to get more time with the child for financial gain. Child support is a necessary means to ensure that children have relatively equal economic experiences across households and ensures that children are fed, that they have a roof over their heads, and that their basic needs are met, all factors that ensure the well-being of the child. As others have noted, this change would be particularly harmful for individuals in abusive relationships who are already vulnerable to being pressured by an abuser into less favorable child support agreements. Domestic violence is a pattern of coercive behavior used by one person to gain and maintain power and control over another in the context of an intimate or familial relationship. One way that abusers are able to leverage power and control is through using economic abuse, which can take on many forms, such as preventing the victim from keeping a job, not letting them have access to family income, and even intentionally ruining a victim's credit. Nearly all victims of domestic violence experience financial abuse in their relationships, and the passage of this bill would grant abusers one additional tool to further limit a victim's ability to be financially independent and free from abuse. Additionally, abusers typically use their children as a way to maintain power and control in their relationship, including threatening to take the children away. The use of parenting time and parenting time credits is extremely problematic and will contribute to an abuser's ability to hold power over a victim in domestic violence cases. Advocates from our 12 crisis centers regularly share the extreme measures that abusers go to in order to obtain custody of their children, to intentionally hoard time away from a victim parent. If this legislation were to pass, abusers will not only use this as a means to take more time with their children and limit access to the victim, but also grant them the power to claim parenting credits, furthering the cycle of abuse. In conclusion, HB 161 would give abusers more power to manipulate their victims, both financially and by leveraging time with their children. Children deserve care and support from parents unconditionally, and parenting time should not be a monetary incentive. The bottom line is the first and foremost priority in any situation should be whether an action is for the benefit of the child. We strongly encourage you to vote ITL on this bill. Thank you so much, and I'd be happy to answer any questions.
Thank you very much for your testimony this afternoon, Ms. Kylie. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we are going to go to Skip Berrien.
Skip, if you could virtually raise your hand. I do not see Skip.
Okay, we're going to keep going here. Next, we're going to go to Jay Markell.
Yes, good afternoon, and thank you for the opportunity to speak. I think a lot of people have already heard the opposition. I'm going to join in the opposition on it. I'll try to be concise. The bill is overly complicated and simply, as you've already heard, doesn't deal with some critical and key issues. There is an alternate way of dealing with the disparities of income within the current statute. It's presently been retained in the Child and Family Law Committee. And the other problems here are that it doesn't reference the parenting rights statute, which requires that a court use the available resources for the best interests of the children. This state, as you've already heard, not since at least 2005, I think Attorney Hastings accurately summarizes the problems with the bill. And she was also one of the architects of the Parenting Rights and Responsibilities Act, which is a significant feat, and she's to be applauded for that. The situation here is that this restricts how child support would be allocated based on a percentage. The experience that I've seen elsewhere are is that you have nothing but fights. People do go for parenting time. It comes down to hours. Not only that, you will probably generate, of the 60 to 70% of people who were self-represented in our court system may not understand this. And I can see the system being inundated with contempts and modifications because they didn't get their 30% this week or that month, and that they either want refunds or contempts. I can see people doing that. So based on that, and for all the other reasons, I'm suggesting that this bill not be allowed to proceed. If there's any questions, I'm happy to deal with them. But in one closing statement, this bill, I think, was based in part on the UNH study, which was published in 2018. My source authority for these kinds of information is actually the Child Support Guidelines and Application by Laura Morgan. I refer to her second edition, which came out last year, and it's probably the leading authority on child support. And it summarizes these things accurately, and I respectfully suggest that legislators refer to that tome, refer to that volume for guidance on how they may want to structure future child support legislation, because this is not the answer.
Okay, thank you very much for your testimony, Mr. Markell. Are there any questions from the committee? Okay, seeing none, thank you. Next, we're going to go to Bill Woodbury.
Good afternoon. Thank you very much for allowing me to speak today. Attorney Hastings, Ms. Kruger, Ms. Kiley, Mr. Markell have spoken eloquently about the many reasons this should be ITL'd. I'm sorry, I didn't introduce myself. I'm Bill Woodbury. I'm an attorney in Laconia, New Hampshire. I practice primarily in family law, but I do other civil litigation. And I currently serve as legislative chair for New Hampshire Association for Justice. We oppose this bill for the many reasons stated already. And I think the only thing that I can add of use to the committee that hasn't already been said is just a quick practical observation. I spent the morning today, as I do many mornings, in a divorce mediation, and the approach often in that type of case is to kind of divide the issues up, talk about parenting, talk about child support, talk about property settlement, things like that. And in this particular case today, the disputed issues were the parenting plan, who's going to take the time with the child and when, and child support. Not unusual, but it crossed my mind as we were doing the mediation, and I knew I would be here today, is that, it would not be so easy to bifurcate those issues, as it is now. And it's much easier to talk about parenting time solely in the context of the best interest of the child. If you don't inject this issue of, monetary gain into the mix, I think that from a practical perspective is the most problematic part of this, and that's that if you inject that monetary incentive when it comes to deciding what the parenting time will be, you've undermined the entire analysis, which should be based solely upon the best interest of the child. So I echo and applaud the testimony of Attorney Hastings, Mary Kruger, Pam Kiley, and Mr. Markell, and simply state that we believe as well this should be ITL. Thank you.
Thank you very much for your testimony, Mr. Woodbury. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to go to Sean Desjardins.
Good afternoon. Can you hear me?
Yes, we can.
So I'm not a lawyer. It's very nice to meet all of you. I am a firefighter paramedic, and unfortunately, I've gone through a divorce. And I hear all this talk about money and time. I pay a lot of money. And I see my kids every week on a rotating schedule. And I'm being crushed, absolutely crushed by the current guidelines. $1,100 a month is a ton of money. And I don't understand how it's doing my children any better when I give it to their mother. It's 2021, not 1982. Women are completely equal to men and should be proud of that. And I feel that with that, they should also have the responsibility of making some more money. I don't mean to be so blunt about it, but it's truly how I feel. Women are equal to men. I want to see my children more. I've talked to my kids quite often about it. They want to see me more. They've asked me to take them to Disneyland, and I feel like garbage when I tell them that I can't take them to Disneyland. I work 42 hours a week on a regular schedule. That's my regular schedule. It's 2 24-hour shifts. Ultimately, that's 4 days a week, midnight to 7 a.m. of the next day. When I come home, I am very tired. It is extremely hard to get up and go out and continue to work to try and supplement my loss, which I can't even do because then I make more money and she's just entitled to more money. I am being crushed, guys. Crushed. And I love my kids very much. I can't explain to you the amount of pressure that I feel all the time. All the time. I am for the bill, or I'm for a better solution. And it has to happen soon.
Okay. Thank you very much for your testimony. Senator French has a question.
Thank you, Madam Chair, and thank you for testifying today. Have you plugged your numbers into this bill to see how it would affect what you were paying?
I believe it would relieve my payments by about $300 a month.
Okay, great, thank you. And you were able to figure that out?
I do a lot of med math.
Perfect, thank you.
No problem.
Hey, are there any further questions for Mr. Desjardins? Okay, seeing none, thank you very much for your testimony.
Thank you, Senators.
Next, we're going to go to Anthony Matrumalo.
Thank you. I'd like to thank the Madam Chair and the members of the committee for allowing me to testify today. My name is Anthony Matrumalo. I'm a certified family mediator with my offices in Londonderry, New Hampshire. And I'm here to speak in opposition to the bill. I understand the reason why some people believe that there needs to be a change in the law. And it's because there's a gray area, right? There are the guidelines. We do have guidelines, and then there are exceptions to the guidelines. And there is a gray area that doesn't really clearly define what when deviations are appropriate and how much those deviations can be. But I'm here, first of all, I want to kind of agree with all of the testimony that has been given today. It made my job a lot easier here because I really want to strongly support the points that were made by Honey Hastings and representatives from the coalition and New Hampshire Legal Assistance and the attorneys that spoke. Every one of I was in complete agreement with everything all of them said. And I would like to challenge the premise that the gray area that currently exists needs to be remedied. I believe it is exactly the fact that we have a gray area that creates a need for discussion and thoughtfulness when trying to develop a parenting schedule that is in the best interests of children. I work every single day with parents who are trying to make these very difficult decisions. And I will tell you that I do not believe there's a more difficult decision that a human being can make than to voluntarily give up time with their children because they believe it's in their children's best interests. Nor do I believe that there is any more selfless decision that a parent can make in some situations. So we do have guidelines. I think the idea that there is a provision in the law that says that even equal parenting time shall not in itself justify a deviation from the guidelines creates this very open dialogue that has to take place between these two parents. So when we talk about the parenting schedule first, we don't even discuss child support. What I do is inject the uncertainty and use that uncertainty to kind of till the field that we're going to be planting, right? So it is a very, very critical, useful tool to help these parents come up with a schedule that they both believe are in the best interest of kids, which I've never had two parents not able to do. And it also then, when we get to the issue of child support, we've already established what's in the best interest of the kids without any discussion about money. And now they can deal with that issue based on the budgets that they have to prepare in their financial affidavits, so they know what the need of each parent is, and they're free to agree to a deviation from the guidelines. So in Mr. Desjardins' case, I don't know what happened or how this, the application of the guidelines was decided, whether a judge decided that or it was agreed to. But there is a provision in there that allows parents to agree to deviate from the guidelines, or for a judge to determine that the application of the guidelines would not be fair and just in a particular case. So we already have those provisions. It's different from the alimony bill because there weren't any guidelines at all. It was like the Wild West, and that provided some bumpers in the bowling alley or some kind of parameters to work with. In this case, we already have the guidelines. So I think eliminating that gray area and that uncertainty will take away much of the incentive that these parents have to stay at the table and work together to determine what's appropriate, both in terms of time with the kids and then what amount of support is appropriate to go back and forth between them. I also want to agree or emphasize what Ms. Kruger said about there being a disproportionate, the fear that there's going to be a disproportionate impact on cases where there is abuse or coercion or an imbalance of power. I think that's absolutely going to be the case. And I think that if there are problems in the system with this gray area, if that's creating problems, I think that can be addressed by training in how to use the gray area rather than a law designed to eliminate it. And last, I will say that, does the state of New Hampshire really want to go out and tell the thousands upon thousands of obligors who are paying the guidelines or who were ordered to pay guidelines that now the state has rethought that and believes that as long as you have 30% time with your children, those guidelines should not be applied. And why were they applicable before in all those cases? And now we've seen the light and they weren't applicable. So I think there are a lot of problems with this. I think they've been articulated by the people who testified before me. And I really hope that you will not proceed with this bill.
Thank you very much for your testimony, Mr. Matrumolo. Are there any questions from the committee? Okay, seeing none, thank you very much.
Welcome.
Margaret, are there folks in the waiting room who would like to testify?
Yes, I do have 3 hands. We have, or 4 hands. Representative DeSimone. I have a John, Mr. Deschardins, and Frederick Berrien.
Okay, let's skip Marion. Okay, before we hear from these individuals, we've had a lot of testimony this afternoon. A lot of it has been repeated multiple times. So I'm going to ask people to not repeat what others have told us, to please tell us things that we have not heard. And I'm going to ask Margaret to have a 3-minute time limit so we can make sure these individuals all have an opportunity to speak with us. Okay, Margaret, let's put the first one through.
All right. John, you should be able to speak.
Hello? Can you hear me?
Yes, we can.
Yes, okay. I have a technical issue. I'm looking at the percentages.
Sir, I'm so sorry. Sorry to interrupt you. Can you please identify yourself for the record first?
Yes, I'm John Avlis. I just zoomed in and I had some questions about the law, about the other way it's drafted. And the first one deals with, if you look at the percentages, goes to 176,000 combined net income, 13, 20, 24, and 26. Right below that, $1 more, and the percentages drop to 12, from 13 to 12 for one, 20 to 18 for 2 children, 24 to 21 for 3, and 26 to 23 for 4 or more. Now, what this means, if you break it down into actual numbers, that creates an imbalance. That creates a situation where somebody making more than another individual is paying less in child support. Let me give you the specifics. If you're earning combined income now, both parents, $20,370 per month, your child support obligation under this proposal would be $1,907. That's not the shared obligation, that is the unshared, that is the straight calculation. And that's your total obligation. If you're earning $10 more a month, $20,000, $20,380, your child support for one child is now $1,750. So you've dropped substantially even though you earn more. Now, what that tells me, that's a no-no. That's something basic you should never allow to happen in guidelines, as you can see. And that tells me whoever did this really didn't understand how the guidelines should be structured. If you want to go further and look at 2 children under the 20,370 scenario, that's $2,933. You earn $10 more and your child support drops to $2,640. I don't think I have to go any further than that, but that is a really basic error that should never happen with somebody well-versed with child support and how the guidelines should be structured. The other question I have is, I noticed in doing the calculations, comparing the two, I didn't do amounts, I can, but I'm looking at percentages. And I noticed there's a bias for families with 1 child. And I'm looking at, if you make combined income $15,000 annually, your current portion would be 25.6% of that net income. The UNH, or this legislation, is 22. So you lose a substantial amount there. If you go down, and that would be about $1,380 per month. If you go down to 25,000 annual income combined, percentage currently is 25, it would be reduced to 22 under the UNH or this legislation. You go down to 35,000, which is $3,450 a month, and your current percentage would be 24.
John, excuse me, we have reached the 3-minute mark.
Okay. Can I make one more observation? And
Sure, very quickly, sir.
Yes. There are scenarios UNH provided where the obligation is less than zero. That is not addressed. Currently, you still owe a $50 obligation in those situations. It's not addressed in the legislation.
Okay.
So I think it's incomplete. It's not a well-written document. I would concur with people that suggest that this be reevaluated and probably a different vendor be selected. I don't know if this was one of those sole selections or not.
Okay, thank you very much. Are there any questions from the committee? Okay, seeing none, thank you very much for your testimony this afternoon. Let's go to the next person, Margaret.
All right. Representative DeSimone, you should be able to speak. You have to unmute.
Yes, thank you. Thank you, Madam Chair and committee. I'll make this very brief for you. I just wanted to speak about one piece that's not in the legislation and has been touched upon a little bit. When you go to court and you start talking about parenting plans and child support, RSA 461-A, the parenting plan is what comes first. The court takes into consideration what's in the best interest of the child first. Then RSA 458C, which this bill is looking to change, is the child support, which comes after what's in the best interest of the child. And my hope is that if this bill does pass, that the court does continue to take into consideration the 461-A, which is in the best interest of the child. Thank you so much for your time.
Thank you very much, Representative. Are there any questions for the representative? Okay, seeing none, thank you. Okay, next, Margaret.
All right, Skip. Skip, you should be able to unmute.
Thank you, Madam Chair. Thank you, committee, for getting a better understanding of this bill in its complexity. I was involved with kind of stimulating the the drafting of this bill in last session, but unfortunately it got lost in the pandemic agenda abbreviations. And so I think those of you who know me realize that I am on this bill because of the best interests of the children. And I think there is a real need for this bill, as you've heard from some people. I have a lot of respect for all the attorneys that have criticized the bill. And in particular, I want to cite Attorney Hastings and her request that there be a committee or a commission or some group of people that try and sort through this, because I heard from a number of people similar to Mr. Desjardins' concerns that fathers in particular seem to be having financial difficulty based upon their requirements with the current statutes. So my sense is that there has been a lot of change in the way in which divorce cases are being handled. And I bring to your attention in particular that there are two cases out of the Supreme Court which have questioned the concept of equal parenting. And I will send you by email the information on those two cases so that you can review that. But it's basically made it so it's difficult when it comes to making adjustments or modifications to use the concept of equal parenting. And so this isn't our shared parenting. And so this is a concept which really does need to be put into statute. And I think as the legislature is overdue in addressing that particular issue. So thanks very much. I appreciate your interest in this, and hopefully within the next year, we can get this sorted out.
Thank you very much, Skip. It's always good to hear from you. Are there any questions from the committee? Okay, seeing none, thank you. And you said there was one more?
One more, yep, Mr. Desjardins.
Okay, he's speaking for a second time.
Yes.
Okay.
Thank you for having me back. Sean Desjardins. Basically, I don't know. Again, I'm not a lawyer. I don't practice law, family court or anything. But there should be a way for the father to supplement his loss in this without being charged. Whether that be work more overtime, second job. Right now, I'm going to be forced out of my apartment. I'm going to lose my vehicle. Like this, it can't continue this way. Something has to break for this. I want my children just as I love them just as much as their mother. My kids love me. They love their mom. We don't badmouth each other. So I feel that somehow there needs to be a way for me to move forward in life. I should be able to buy my children a house and leave this world knowing I'm leaving some security behind for my children. And that's it. Thank you.
Thank you very much for your testimony, Mr. Desjardins. Are there any questions? Seeing none, thank you again for your testimony. That's it, Margaret?
That is it, yes.
Okay, I'm going to go ahead and close the public hearing on House Bill 161. Okay, next we're going to go to House Bill 142. And I will recognize the prime sponsor, Representative DeSimone.
Thank you, Madam Chair. And committee members, nice to speak to you again. This bill is very simple. It's all it's doing is updating RSA 458:7, which is more than 20 years old. And it just doesn't, the current RSA does not reflect the changes in society insofar as same gender marriages. So as opposed to the RSA saying husband or wife, this bill just simply changes it to state in the case of adultery of either party. And in the case of other misconduct, in this section, other sexual misconduct means voluntarily engaging in, but is not limited to the intentional touching. And it goes on. I don't need to use all of the graphic words, but between, it gets to the, between a married person and someone other than the married person's legal spouse. Again, it's taking out the gender classification and generalizing it to encompass same gender marriages. And also in the current RSA section 7, it says currently when either party is a habitual drunkard and has been such for 2 years together, this bill seeks to change that to state when either party habitually abuses alcohol or drugs and has been doing so for more than 2 or more years. So what it's doing is it's adding the drug aspect of it, which was not in the RSA's 20 years ago. So pretty much that sums up the bill, and I hope you can understand where I'm going with this and see that it should be ought to pass. Thank you.
Okay, thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you. Okay, next we're going to, let's go to Honey Hastings.
Thank you again, Senator Carson and members of the committee. I don't know if I said I'm from Temple, New Hampshire. I was a lawyer for a lot of years. I'm now doing mediation only. I oppose House Bill 142 for two reasons that I'm going to describe, but let me just give you a little background. The overwhelming percentage of divorces and legal separations, and I incorporate both of them when I say divorces, there's not many legal separations, are based on no fault, irreconcilable differences. Less than 0.5% of divorces are granted on any fault grounds, and there's 7 of them or some number like that. Last year, there were only 12 fault divorces, 0.37% of fault. What difference does it make if the court finds fault? Well, the court has to find that the fault existed, that it caused the breakdown of the marriage and also caused some other injury to the innocent spouse. Then they can award more than half the assets to the innocent spouse. In my experience, and both as a litigator when I did that and reading cases since then, the difference is not usually much. You know, it might be 52%, it might be 54, 55%. It's not that someone gets 75 or 80% of the assets. In many cases, I used to ask clients who were interested in this, you know, well, given that all you have is the house with $20,000 in equity in it, is it really worth it? What you might get as a difference. There are lots of other factors in 458 justifying other than an equal split. And one that I think could apply in a lot of situations, the age, health, social or economic status, occupation, vocational skills, employability, separate property, amount and sources of income, and needs and liabilities of each party. That I think would be helpful in many more cases than the fault ones. But to get to the two reasons, a recent New Hampshire Supreme Court case has eliminated the need for this bill. I think the reason this bill was put up was the Blanchflower case, which came out in 2003. In that case, 2003, keep in mind, before same-sex marriages were allowed in New Hampshire, they found that the definition of adultery only applied to heterosexual couples, and it had to be sexual intercourse. It couldn't be some sort of foreplay. It said, looking at dictionary definitions, that a same-sex couple simply could not commit adultery. That was the Blanchflower ruling. And then what happened? Things changed in our society and our laws. New Hampshire allowed same-sex marriage. The US Supreme Court said same-sex marriages have to be allowed. So just over a month ago, on April 1st, the New Hampshire Supreme Court overruled Blanchflower. Not a common thing for them to do. They said, basically, that's old law. It doesn't apply now. And it specifically said we were wrong. You know, it no longer applies because of the changes about same-sex marriages, that same-sex couples could not commit adultery. We now understand that they can. And then it provided a definition for adultery as a fault ground for divorce. And then what is the additional definition of sexual intercourse under the adultery statute? Because what this bill would do is essentially give you a new definition of sexual bad behavior that they would equate with adultery. The new definition is from the Supreme Court, I think takes care of it and is a much better definition because it's simpler. Adultery is defined as a voluntary sexual intercourse between a married person and someone other than that person's spouse, regardless of the sex or gender of either person. For purposes of this definition, sexual intercourse shall include heterosexual intercourse involving penetration of the vagina with the penis and intercourse involving genital contact other than penetration of the vagina with the penis. So there is in a very small number of words applying essentially that it can be intercourse or it could be genital contact. So this would apply to everyone. And I've given you in the written testimony that I emailed you a link to the Blaisdell case. I think when that came out, this bill was no longer needed. And thus, I hope you will vote it down. I think that if this bill passed, it would increase divorce litigation. It so enlarges the definition of, well, I say the definition of adultery. Technically, it says sexual misconduct, that any touching for arousal or gratification is bad behavior and you can get more assets. So I think this would be a simple touching of breasts or buttocks could be sexual bad behavior. And to be frank, I think more married people commit breast or buttock touching with someone other than their spouse than those who have genital contact with such a person. I think it happens much more commonly. And so their spouses, if they learn that there was this touching, they can litigate a fault divorce. So given the Supreme Court's new and practical definition, this bill's expanded definition is not needed, should be rejected, and the bill reported as inexpedient to legislate. There is the thing of the habitual drunkard, but frankly, there's so few cases, 12 with all the fault grounds last year. I just, the better thing would be get rid of all fault grounds, but we're not at that place today. I'm not asking that. I think you just need to kill this bill, and we'll just go with what the Supreme Court told us.
Thank you very much for your testimony, Ms. Hastings. Are there any questions? Senator French.
Thank you, Madam Chair, and thank you, Ms. Hastings. One of my questions was, do you have the bill in front of you?
Yes.
Line 1.
Yes.
Would it be better just to put a period after repealed and delete everything after it?
Yes.
Okay, thank you.
Okay, are there any further questions? Seeing none, thank you very much, Ms. Hastings. Next, we're going to go to Aura Schwartzberg.
Aura, if you could virtually raise your hand. I do not see Aura.
Okay, next we're going to go to Jay Markell.
Jay, you should be able to unmute.
Okay, did that unmute it?
Yes, it did.
Yep, you are.
Okay, thank you. I appreciate the input. Blaisdell did alter some of the landscape. However, there's a couple of things to be noted I think in legitimate dispute with Attorney Hastings. Number one, approximately 34 out of our states still recognize fault grounds as a basis for a divorce. If the percentages were that small, then I guess I should probably end up assuming that I did have, in fact, one of the few fault grounds, supposedly, that was pled effectively for a divorce, number one. Number two, what the divorces are granted on has virtually no effect with what is initially pled. Number three, so in other words, there are a very high percentage of cases, in my experience, that plead in the alternative. They will plead irreconcilable differences, and they will plead fault grounds of varying descriptions. Okay, whether you prevail on it or not, the law should nevertheless allow you a remedy, okay, to be able to be heard. Now, for example, number one, House Bill 142 in the second category reaches conduct that might not otherwise be available. Now, I realize that was drafted before the Blaisdell decision. Blaisdell does greatly expand that, does expand that. However, this reaches, however, in its sense, it does reach conduct that Blaisdell and even expanded definitions of adultery don't reach. For example, not all offensive conduct in marriage has to be genital contact. That is a question for the parties to decide. But going back to fault grounds for just a minute, if you say that there are to be no fault grounds, then you have to look at RSA 457A, which specifically precludes any mention of fault that doesn't affect the children from coming into the case. So you would be effectively precluded from it unless it had an effect on the children. Number three is that I've seen the opioid problem and the drug problem in this state is legendary. And to restrict people on grounds of chronic alcoholism only or drunkenness as the present statute exists simply completely ignores a relevant problem. So are fault grounds needed? Yes, they are, because they have to be able to plead relevant conduct, which affects people in their marriage, and that also can affect the property division. Because fault grounds are mentioned specifically in there. In addition to which, I think you would find that even if you said, well, maybe what we ought to do is amend this, then what you could do, if you were assuming none of that had any merit, then what you could do is that you could simply amend the other sexual misconduct and allow it to go forward, certainly on abuse, on drug or alcohol abuse. Now, by the way, I didn't invent this. For example, Massachusetts, our neighbor to the south, has had drug, gross and confirmed, I think it's intoxication by use of alcohol or drugs. There's a lot of other states that have this. This is not new, this is not unusual, and it's not uncommon. It simply updates something which everybody knows. And these grounds are frequently pled, in my experience. I think it does update the statute. While one can say that it would be nice to be able to eliminate fault grounds, they're nevertheless here. Imagine telling somebody who is truly aggrieved that they have no cause of action. And these also are things that a court should hear before it makes its decision on on how it's going to award property, alimony, or anything else that may matter. It's probably one of the reasons why 34 out of the 50 states still retain fault-based divorces.
Thank you very much for your testimony, Mr. Markell. Are there any questions from the committee? Seeing none, thank you. Margaret, are there folks in the waiting room?
If anybody else wishes to testify, you can virtually raise your hand. I do not see any hands raised.
Okay, I'm going to go ahead and close the public hearing on House Bill 142. I am going to put the committee in recess until 10 after 3 to give folks a little bit of a break. So we'll see you again at 10 after 3.
Thank you, Madam Chair.
Okay, we'll just wait another minute for Senator.
I'm ready.
Khan.
Let's go.
I know
Let's
you're-
go.
Harold, you're always ready. We're just a few more seconds. There's Senator Whitley, and let's see if we can get Senator Khan back.
We're gonna do a lightning round, right? 1 minute. Boom, 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 boom.
No, it's okay. We have this one and we have one more after this, and then we will be finished for the day. Well, I'm gonna go ahead and get started. The committee will come out of recess, and I'm going to open the public hearing on House Bill 495 and recognize the prime sponsor, Representative DeSimone.
Thank you, Madam Chair, and thank you for that little break. I neglected, and I apologize, to introduce myself. I'm Deborah DeSimone. I represent Rockingham 14, Atkinson and Plasto, and thank you again for hearing me. And to Senator Gannon's point, I'll make this as fast as I can. Maybe it'll be a lightning round.
Thank you, Representative.
Thank you for letting me testify today. I just want to open my bill, House Bill 495, which is actually related to House Bill 494. The bills are similar, and in that they protect the constitutional rights of parties involved in restraining orders. House Bill 495 fills a void in RSA 461-A:10, section Roman numeral 1, stating that with such conditions and limitations as the court deems just, this bill specifically exempts domestic violence issue orders because they represent a compelling government interest. While such orders infringe on constitutional rights, they are narrowly tailored to protect victims from physical abuse, and there is no less restrictive way to accomplish the purpose.
Representative?
Clears up a void in an area of the statute. Yes.
You keep coming in and out. We're not getting your complete testimony.
I'm terribly sorry.
Oh, that's okay. It's the age of Zoom.
It is. Basically, let's do this quickly. This bill, I think I'm going to come in and out again because I have traffic going by my house. The bill simply clears up a void in the area of the statute where parties will no longer be able to harass, stalk, or in any other prohibitive activities abuse a person. With the onset of things like verbal abuse, harassment by texting, by Facebook, and things of that sort. That's what this will accomplish. And it will fix the void in RSA 461A. Thank you.
Thank you very much for your testimony. Are there any questions for the representative? Okay, seeing none. Thank you, Representative. Next, we're going to go to Richard Head.
Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. The bill as written does not fix any voids that currently exist. The bill as written would require any judge who is issuing an order regarding parental rights and responsibilities, if that order were to, as the bill says, infringe on any rights or responsibility that's enumerated in a state or federal constitution, the court shall identify the rights being infringed and the compelling objective of the infringement. Not really clear what the gap is that's currently missing because the courts under the Constitution are not allowed to issue unconstitutional orders. And for the same reason that the legislature does not, when it issues a piece of legislation that is subsequently challenged as being unconstitutional, does not write in the legislation that this bill is unconstitutional. Courts don't do that, also don't say this is an unconstitutional order because they try very hard not to issue unconstitutional orders. And if there is an order that is ultimately challenged as being unconstitutional, it is a determination for the Supreme Court to make. The other part that this bill, or the other thing this bill does is in the last sentence, starting on line 8, says that any party aggrieved by any order not meeting this standard may petition the court to have the order modified or vacated. And in current practice, that would be a motion for reconsideration. So anytime an order is issued, a party can issue and seek reconsideration or clarification or amendment to the order if it believes that there is an issue of concern. Finally, the other part of this bill is that it would require the court not only to say that it is infringing upon the rights of a party or the constitutional rights of a party, but also to state a compelling government objective in achieving the infringement. And there are ways in which the constitutional rights can be impacted by either legislation or the court, and that is subject to various levels of scrutiny by a reviewing court, in the Supreme Court in our case. So there can be strict scrutiny, which is essentially what this statute requires, which is that there has to be a compelling state interest and that the, in this case, an order is narrowly tailored to achieve that interest. That does not apply to all constitutional reviews. So there are other ways in which a constitutional, an alleged constitutional violation is evaluated, and there's an intermediate scrutiny that there has to be an important or substantial interest or a rational basis scrutiny. And it depends on sort of what you're talking about and what is the context. And typically you see it in sort of what is the legislative authority given to courts, and then whether or not that legislation is either on its face unconstitutional or as applied, which would be the court's order, as to whether or not the court's order applying that statute is unconstitutional. In the case of 461A, where it says that the court has a certain amount of discretion in making an order, that does not authorize the courts then to violate constitutional rights. So there is nothing gained and there's no sort of void that is being filled by requiring a court to say it is issuing an unconstitutional order when its objective is not to issue unconstitutional orders, similar to the legislature not issuing unconstitutional pieces of legislation. I'd be happy to answer any questions if the committee has any.
Okay, terrific. Thank you very much, Mr. Head. Are there any questions? Senator French has a question.
Thank you, Madam Chair, and thank you, Mr. Head. I'm looking at that section now, and is this bill to address Second Amendment rights?
It very well. There are certainly Second Amendment rights that I suspect you may hear testimony on, and there are various statutes that do allow in domestic violence cases, stalking, Child Protection Act, or certain bail conditions that allow weapons to be removed. This bill would not include anything issued under RSA 173B, but those are the 4 statutes that you tend to see where the authority is granted about weapons. Whether or not an order under 169C, the Child Protection Act, could be implicated by this bill is perhaps less clear. The bill specifically excludes 173B, but not the other statutes in which weapons can be held under a protective order. 461A is not a statute that you typically see protective orders that deal with weapons. It's usually those other statutes.
B, right?
I'm sorry?
This talks of, I RSA 173B.
173B is the domestic violence statute. Yes,
And that would be the firearms confiscation, correct?
that's one of them. And the other three where you see it are 633-3A, which is the stalking statute, 169C, which is the Child Protection Act, or 597, which is bail, criminal bail, which would not presumably get triggered by parental rights and responsibilities. Child Protection Act, maybe.
This specifically just refers to B, though, I believe, doesn't it?
That's correct. 173B is this, and it specifically says other than one brought under 173B.
Okay, thank you.
Are there any further questions? Okay, seeing none, thank you very much, Mr. Head. Next, we're going to go to Mary Kruger.
Thank you, Madam Chair and members of the committee. I'm Mary Kruger. I'm an attorney at New Hampshire Legal Assistance. We have a domestic violence advocacy project where we represent victims and survivors of domestic abuse in divorce, parenting, and in domestic violence under 173B as well. We are opposed to this bill and are asking the committee to vote inexpedient to legislate. This, I would second all of the comments that Mr. Head made. I will point out, based on Senator French's question, that there is Supreme Court law, Magoon versus Thorogood, which is a case under 148 NH 139 in 2002 that was decided, where the sheriff department misinterpreted one of the restraining orders issued under the companion statute to this, which is 458, and the second bill that we're hearing today is addressing that, but they're the same language in these two sections of the statute, that because there was a restraining order under this statute, did not allow for relinquishment of weapons. So basically, this restraining order would not take away someone's firearms, and it does not have, the court doesn't have authority under the statute to do that. And that was clarified and decided in that case. So there is no Second Amendment problem with the current statute with regards to firearm possession. These restraining orders that are available, in this particular one is under the Parental Rights and Responsibilities Law, are really meant for instances where someone isn't a victim of abuse as it's defined under RSA 173B, which is the domestic violence law, where someone would need to demonstrate that there was an act of abuse, plus that defendant poses a credible present threat to the safety of the victim. And that law is meant to really address immediate and present danger of further abuse. Whereas this law would address situations where that's not necessarily the case, and but someone is being harassed or perhaps verbally and emotionally abused, coercively controlled, where there's financial abuse, things like that might warrant the court putting some restraints in place against the other party to just prevent them from showing up at their work or calling their work or showing up at their home, or following them, or for them to escalate in any kind of abuse, such as harassment, stalking, assault, criminal trespass, criminal mischief. So basically just tells the person, don't do these things. And it provides for a mechanism by which someone could enforce the order if they committed a crime like criminal mischief or a criminal trespass, that they've been on notice, essentially, that those things aren't permitted. And that's really what the order does. as a practical matter on the ground. And it is often utilized in courts for a couple of other things. One, where maybe there is an RSA 173B domestic violence order in place, but that those typically are issued for 1 year. And so sometimes as a divorce case or parenting case is processing, it's getting ready to expire. And the victim may decide, I don't feel like I need to have the 173B order, which is really a no contact order with much more restrictions, including restrictions from the defendant possessing any firearms, that they may decide, the victim may decide, well, if I have this other restraining order in place, I would feel protected. I don't necessarily need that no contact provision. And it's sometimes a way to help people kind of move on and resolve things and tamp things down. So it's a tool that is helpful sometimes in that respect, in the context of when parties are separating and there's been domestic violence. And I would also say the other way that the court uses this is where there's parents who are just high conflict, and the court needs to issue an order sort of mutually to tamp down the conflict, and just telling people, okay, like here's some parameters between the parents. It really has nothing to do with the children. And there's nothing in the current statute that addresses contact with the children or preventing it or restricting it in any way. So it's meant to, it's used that way sometimes as well. So this additional provision that would be inserted, I think, is unnecessary given what we currently have, and for a number of the reasons that Mr. Head also mentioned. Thank you.
Thank you very much for your testimony, Ms. Kruger. Are there any questions from the committee? Okay, Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Attorney Kruger, for taking my question. So going to your point about, when this type of order would be used, I'm wondering if you could share, based on your experience with your clients, whether there are, reasons why a victim or survivor might not want to pursue a 173B order and rather go this route instead.
Sure. This is certainly a less restrictive means of restraining someone. And it may be perceived less onerous for good reasons. And so it could be less dangerous for a victim to just request that the court issue an order if the victim files for a divorce or a parenting case, and to make that request. And that may be a safer route for a victim to choose over filing for a 173B, which again is layered with a variety of no contact provisions, and it could instigate an abuser in some circumstances.
Thank you. And a follow-up, if I may?
Yes, follow-up.
Thank you, Madam Chair. Thank you for taking my follow-up. So to sort of take that to the next level about sort of the levels of these types of restraining orders, in the ones we're talking about in this situation, this type of order is not enforced by a police officer. Like a police officer is not going to come to the house and enforce it unless an actual crime is committed, correct?
That's right. So it does say that the person could be restricted from coming to the home of the other individual who's protected. So if they actually come to the home, they could be, they're sort of on notice. So then law enforcement, if it gets involved, could charge criminal trespass. Whereas if this order didn't exist, they may or may not have the same ability to charge that crime. But the person has been noticed that this is something you can't do. And that's sort of the way in which law enforcement could say, okay, you knew by virtue of this order, you can't come to this place. Now you're here. That's criminal trespass. They may be criminal trespassing anyway, even without this order, but I think it's just much more clear because of the notice that the other party has.
Thank you.
Okay, are there any further questions for Ms. Kruger? Okay, seeing none. Thank you very much, Ms. Kruger. Next, we're going to go to Pamela Kiley.
Hi, good afternoon. For the record, again, my name is Pamela Kylig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. I'm here in opposition of HB 495, which would make it harder for victims to get restraining orders in parenting cases. Thank you for the opportunity to testify. As noted, this bill amends RSA 461A10, which would directly impact restraining orders in parenting cases and would limit an individual's access to an essential means of protection. Advocates who are in our courthouses every day across New Hampshire tell us that it has become increasingly difficult to obtain a protective order under RSA 173B, which is the gold standard for protections for domestic violence victims. Alternatively, restraining orders within marital or custody proceedings are another option that individuals rely on in lieu of protection under 173B. Advocates have shared the extreme circumstances that victims of domestic violence experience while navigating parenting cases with their abuser, and have seen many cases where restraining orders under the parental rights statute were an essential means of protection and granted necessary relief to victims and their children. Victims should be able to access these types of restraining orders without having to go through additional barriers to demonstrate that the threat they experience is real, especially when experiencing domestic violence and abuse. Additionally, these restraining orders ensure that judges and courts have the discretion to act should one party continue to further control and harass the victim. Judges should have the ability to make discretionary decisions as they need when it comes to ensuring that victims and their children are protected from abuse. There were a lot of questions about RSA 173B. Being granted a protective order under this statute is an extremely high bar and is very complicated. Many people need the assistance of an attorney to help them seek that relief, yet only 12% of victims have legal representation when petitioning for domestic violence protective orders. Moreover, restraining orders are not automatically granted. Although more than 7,000 domestic violence petitions were filed between 2018 and 2019, more final protective orders were denied than granted in our state. Even when there has been physical abuse, victims have to prove they are in immediate danger. This leaves many victims vulnerable and in situations where they have experienced bodily harm, such as a broken arm, and are still denied restraining orders under 173B. Victims must then seek another alternative path through restraining orders such as those we are discussing today. Although these restraining orders do not carry the same weight as a domestic violence protective order, it still puts into the agreement or court order that one person cannot contact the other person. Sometimes all a victim needs is the weight of the law to say, "Stop harassing me," in order to be protected from abuse or prevent violence from escalating. In conclusion, survivors already experience so many barriers to obtaining a protection order in the first place, and we should absolutely not be making this process harder. We need to protect and preserve survivors' access to restraining orders, and it might be the only thing they have to keep them safe in that moment. We strongly urge the committee to vote ITL on HB 495 and ensure that domestic violence victims have access to restraining orders that are so critical for preventing further abuse. Thank you so much.
Thank you very much for your testimony, Ms. Kiley. Are there any questions from the committee? Okay, seeing none, thank you very much. And next we'll go to Jay Markell.
Yes, thank you very much. Can you hear me?
We sure can.
Okay, thank you. Yeah, I'm a little disturbed by what I'm hearing here. I was involved in drafting this legislation, and I'm a little disturbed because, first of all, this has absolutely nothing to do with abuse, and this has absolutely nothing to do with RSA 173B orders. In fact, they're specifically exempt. That's number one. Number two is that this does not, when you read the bill, all it says is enumerated rights under the federal and state constitution. That means if it's not an enumerated right, okay, it's probably not subject to strict scrutiny. Now let's deal with the levels of scrutiny that were mentioned before. First, enumerated rights, basically under the federal and state constitutions, do get what's called, under the constitutions, do get what's called strict scrutiny. Number one, that means that it has to basically be impacting on it has to represent a compelling government interest, number one. Number two, the order or law has to be narrowly tailored to be able to achieve that compelling government interest. And number three, there must be no less restrictive way of accomplishing that interest, or if you want to say objective. Now, that's the way these things are interpreted. Oddly enough, when you look at both RSA 461A, when you look at both of the statutes that are involved, you will find that both of them actually prevent you from going near somebody's place of employment or anything else like that, or staying away from their home. And that's fine. And the reason why is you have no rights enumerated under the federal state constitution to be on somebody else's property or to be on your spouse's property or anything else. Those are not enumerated rights. Okay. However, it's interesting to note that neither of them, when you look at both the parenting rights statute and when you look at the divorce statute involved, prevent you from attending the same house of worship. Okay, that's specifically exempted and it's not in there. So if there's no implicit recognition that and you do have a First Amendment right of freedom of worship, and you also have that under, I believe it's Part 1, Article 22 of the New Hampshire Constitution, or at least free speech. So those things don't apply. We recognize and appreciate the problem of domestic violence. We recognize and appreciate that people are not allowed to harass or stalk or do anything else. The problem comes in when justice is not being served. And basically the intent of this bill, let me just see if I can get it out here for you, okay, is that it improves the administration of justice because it provides clear and measurable guidelines for courts to follow. Now, in some of the documents that I think I sent down last night, you may see the Bunza case, which came out in 2019. You may also see a case from the Massachusetts Supreme Court called Shack, which deals very effectively with these issues and brings them to the intent and brings them, because they are worlds apart from the testimony that I'm hearing, back to the level of constitutional review. These are enumerated rights. They have nothing to do with domestic violence. They do have nothing to do with harassment. They have nothing to do with abuse or neglect. And the reason why they don't is because you have no constitutional right to abuse anyone or neglect anyone. You have no constitutional right to harass anyone. And you certainly have no right to abuse anyone under RSA 173B. Those things stand on their own. All this does is improve the administration of justice. Now, when you're looking at the three levels of constitutional review, okay, first are the fundamental rights that are enumerated in the Constitution. Number one. Number two, intermediate scrutiny, which would be stay away from this person, stay away here, or whatever else. That a stalking order is going to pass on that basis, because that's going to have intermediate, that's going to catch intermediate level of scrutiny, okay? Because those are valid time, place, and manner restrictions. Then the third level of scrutiny, which certainly doesn't apply here, is rational basis review, which applies to economic and social legislation. So that means a government can regulate how many people sit in a restaurant. It means that a government probably can zone for how you can use your property. There are three completely different things. And what this does is that this is, by the way, very simple and easy to do. All it says is that, I'll give you a perfect example that was brought up in the Child and Family Law Committee last year, okay, earlier in this matter. I was asked the question of what happens in a parenting case if somebody owns a gun and leaves it laying around. Doesn't that loaded? And I have a 5-year-old children. A question, something to that effect. And the answer is, can a court prevent me from doing it? And the answer is probably yes, for a couple of reasons. The reason why is you may have a Second Amendment right to keep and bear arms. However, you do not have a Second Amendment right to leave a loaded gun around where a 5-year-old can get it, because that's certainly not an enumerated right. And besides that, it's probably also chargeable as criminal reckless conduct criminally. So that's not a Second Amendment issue. Now, to carry this into real life, I emailed you the Bunda decision. I hope you get it and read it. That was from the New Hampshire Supreme Court. I emailed you the Shack decision from 2020, which deals in the First Amendment context and deals with free speech. Now, in my own personal practice, I can tell you that just me, I've seen outside of the restraining order context, people ordered with no restraining orders in place and no civil restraining orders in place to address each other civilly, to also not bring up the past. This wasn't a recommendation. These were court orders, okay? I also have one where there was a law that admittedly a contentious case, but as part of the restraining orders, we brought up to the court a First Amendment right that a party had to sue the other party. They were not married to each other, for extensive damage done to that party's house. We brought that to the attention of the court. The court became visibly upset under the First Amendment and said this should have been brought to this court's attention. And this is the second day of trial, that the other side wanted this enforced, okay? And the court ordered it. We filed a motion for reconsideration, okay? And the court attempted to justify saying that you can only talk about party, you can only talk about the children. That's all you can do. That is prior restraint, okay? And there was and we brought it to the court's attention under the First Amendment. And please be aware the Shack decision, okay, which is basically quoting well-settled United States Supreme Court law as to when prior restraint is acceptable. So this is basically simply reflecting Constitution. Everything I have heard, okay, has nothing to do with this law. And the other thing that it does is that it not only improves the administration of justice, however, it also provides a factual and legal basis for appeal. Because I had heard people say before, if you don't like an order, just appeal it. Well, the practical aspects are that people can't afford to appeal them. Appeals are tedious and time consuming. You can be contempted and jailed for an order under a contempt citation, which is largely unreviewable because in New Hampshire, contempts are basically at the discretion of the court. Now, as a practical matter, what is wrong with a court simply pulling out its constitutional handbook, okay, and saying, and writing in the following orders? What is wrong with a judge who can't write, I recognize that this is a constitutional issue, and you fill in the blank. However, I am making this order because of the following, okay? And simply providing a basis for the order. Now, I challenge anyone to tell me why that's wrong or why a court can't do it if there is an infringement on a constitutional case. And once again, it must be an enumerated right. So you don't have a constitutional right to parent, okay? You don't have a constitutional right to deprive people of parenting. You don't have other kinds of rights that people think they have. This is narrowly drafted. And by the way, if I may respectfully point out, to achieve a compelling government interest, which is the enforcement of constitutional rights and improve the law.
Okay, thank you very much, Mr. Markell. Are there any questions from the committee? Okay, I will note, Mr. Markell, that we did receive a concise position paper from you on House Bills 494 and 495.
Thank you.
Thank you very much, Mr. Markell. Margaret, are there folks in the waiting room?
If anybody else wishes to testify, you can virtually raise your hand. I do not see any hands.
Okay, thank you very much. We're going to go ahead and close the public hearing and House Bill 495. Okay, next we're going to hear the final bill today, which is House Bill 494. And I'll recognize the prime sponsor once again, Representative DeSimone.
And again, thank you, Madam Chair. I hope I don't break up as much as I did the last time. I'll make this even quicker for you, Senator Gannon. The difference between House Bill 494 and 495 is that House Bill 494 speaks to RSA 458:161. That's the only difference. It does the same
Oh, here we go again.
It does not in any way, manner, or form. It does not in any way, manner, or form affect the domestic violence RSAs at all. I don't want to infringe upon those. So that's where I am with House Bill 494. It will just change RSA 458:161. Thank you.
Thank you very much, Representative DeSimone. Are there any questions? Senator Gannon.
Representative DeSimone, have you heard about the great broadband access we're going to provide you? That was a light moment.
Yeah.
Thank you. Thank you, Representative.
Okay, are there any further questions for Representative DeSimone? Seeing none, thank you very much for your time this afternoon, Representative. Okay, next we're going to go to Richard Head.
Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. As was stated, this bill is very similar to the last bill, House Bill 495. And I'll be happy to incorporate what I said in that bill into this bill. I'll just add a couple things in that, again, probably well-meaning bill. I will say it is a well-meaning bill, but it is unnecessary and does not sort of have any particular basis in terms of a need. There, as we heard in the last bill, if there is a violation of a enumerated constitutional right in an order, that order then provides, and the Constitution provides the factual and legal basis for an appeal. What is written in the order by saying we're violating your constitutional rights does not create a factual or legal basis for the appeal. It's the Constitution and the facts of the case that provide the factual and legal basis for the appeal. And those appeals can be taken similar to, as you heard in the last bill, the Shack case in Massachusetts, where the issue there was a non-disparagement order and a First Amendment issue. The court issued an order that was taken on appeal, much like a similar order could be taken on appeal here in New Hampshire. And the Supreme Court would make a ruling as to whether or not the particular facts in the particular order in the New Hampshire case violated the First Amendment. And there may be other ways of writing an order that would not violate the First Amendment. And it is simply an unnecessary provision in terms of trying to put in a requirement that you say we're violating your constitutional rights, where it is a goal of the court, similar to, as I said, with the legislature, not to do that. It is also not narrowly drafted because it says essentially any enumerated right under the federal state constitution. Not quite sure what is being targeted by this. And there are no clear or measurable guidelines being issued. It simply says, to the extent the court believes it is infringing upon a constitutional right, that it's doing so, and what is essentially under a strict scrutiny basis, the requirement or the need for it. I think you would find that anytime you're getting into this area, the court is going to be issuing an order describing the basis for its decision. That is the purpose of an order, and that's the purpose of a court's order. So really very unnecessary and seems driven towards creating more litigation. And again, anyone who disagrees with an order is always free to file a motion for reconsideration, motion for hearing, or seek an amendment based upon their review of the order and the issues that they may see as being raised by that order. I'd be happy to take any questions. Thank you.
Thank you very much for your testimony this afternoon, Mr. Head. Are there any questions for Mr. Head? Okay, seeing none, thank you very much.
Thank
you. Okay, next we're going to go to Mary Kruger.
Thank you, Madam Chair, members of the committee. Mary Kruger, New Hampshire Legal Assistant. I would like to incorporate my testimony on House Bill 495 into this House Bill 494 testimony. And we are opposed to this legislation and ask the committee to vote in expedient to legislate. A couple of things I'll add. In House Bill 494, it specifically says, if any order issued under this section, and then it goes on, this section refers then to the section which is 458.16, which is entitled Temporary Relief and Permanent Restraining Orders. So it would be limited to any orders issued in that section alone. What's important is that is the section that addresses restraining orders, not only the kinds that we discussed under House Bill 495 that would restrict somebody from going to someone's home or place of employment, but also other things to restrict the transfer of property in a divorce case, because a divorce case, the court has jurisdiction to deal with marital property. And I think that this being inserted in that section makes it quite confusing for a court to now have to sort through what, if any, order it's issuing might infringe upon a constitutional right. It's fairly broad in that respect. I did hear Attorney Markell discuss a couple of examples where courts issued what sounded like parenting orders that would say things like the parents, should not disparage the other parent in front of the child, or not talk poorly in front of the child, or you can only talk about the children if you're discussing something between the two of you. And I'm not sure that those things, if the court's looking at the best interest of the child, are infringement on free speech rights. If they certainly were, I would agree with Mr. Head that that would be properly appealed under the Constitution, and that the Supreme Court would be allocated with determining whether limiting someone to not disparage the other parent in front of their child was appropriate under the circumstances, or deciding whether it's rational review or strict scrutiny, and making that determination about the court's order. So there's already a remedy available. That's the appropriate remedy given the structure of our court system.
Okay, thank you very much for your testimony. Ms. Kruger, are there any questions for Ms. Kruger? Okay, seeing none, thank you very much. And we're going to go to Pamela Kylie.
Hello again. It's great to provide testimony again this afternoon. Thank you so much for this opportunity. My name is Pamela Kylie, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. I am here in opposition of HB 494, which would make it harder for victims to get restraining orders under divorce proceedings. As you heard, HB 494 is nearly identical to HB 495, which I previously testified on in the earlier hearing. The main difference is that instead of restraining orders under New Hampshire's parental rights statute, this bill would impact temporary or permanent restraining orders in divorce proceedings. I will keep my testimony brief, but wanted to highlight the specific impact that this bill would have in divorce cases, in addition to what I already shared today. I think it's really important to note that we've heard from advocates how important these types of restraining orders are in order to address the ongoing abuse that victims might experience throughout divorce proceedings. For example, abusers often utilize financial abuse as a means to maintain power and control over a victim. These types of orders help mitigate and limit further attempts to financially abuse a survivor, such as preventing an abuser from dropping their insurance, taking a victim's car out of their name, ensuring that the gas line or electricity is maintained, and so on. These types of relief are so critical and help ensure that survivors and their children are not at risk of becoming homeless and that the victim's safety is supported long term. Like HB 495, these restraining orders ensure that judges and the courts have the discretion to act should one party continue to further control and harass a victim. We have seen cases where defendants have continued to file unnecessary ex parte motions with the intention of controlling a victim's time and burdening them with excessive court dates. The current statute allows judges to intervene should a defendant intentionally try to abuse the court rules as a means to punish the victim and demonstrate a documented history of domestic violence to address the pattern of abuse by the offender. This bill would limit the discretion that judges have to intervene in these moments. Again, survivors already experience so many barriers to obtaining a protection order in the first place, and we should not be making this process any more difficult. We need to protect their access to restraining orders, and I really urge the committee to please vote ITL on this bill and ensure domestic violence victims have access to restraining orders that are so critical from preventing further abuse. Thank you so much, and I'd be happy to answer any questions.
Thank you very much for your testimony this afternoon, Ms. Kiley. Are there any questions from the committee?
Senator Karen has one.
Senator Khan, you have a question?
No, we've heard from Ms. Kiley similar testimony on both bills. No, I don't have a question.
Okay, thank you very much. And thank you very much, Ms. Kiley.
Thank you.
That would be my comment. Thank you. Thank you to her and to the others who have really helped raise the questions and talked about the legal connections here and judicial rulings. This is an unfamiliar area of law for me, so I've learned a lot. Thank you all.
Thank you. Margaret, are there any folks in the waiting room?
We do have Representative Toll and Representative Perez.
Okay, let's go to Representative Toll.
Honorable members of the Senate Judiciary Committee, for the record, my name is Amanda Elizabeth Toll, and I'm a representative serving Cheshire District 16, and I'm also a survivor of abuse. Restraining orders can play a critical role in helping victims safely leave abusive relationships. These restraining orders are so important for courts to grant relief to survivors when no other options to ensure their safety are available. It can be so hard to leave an abusive relationship, especially when children are involved. Many folks feel great fear about leaving because they are scared courts will give unsupervised time with their children to their abuser. Some folks are financially dependent on their abusers or dependent on an abusive spouse for healthcare. There are already so many obstacles for leaving, and restraining orders are already challenging to obtain. Let's not make a hard situation even harder for survivors by making it harder to obtain an essential and effective tool in exiting an unsafe situation. In my own divorce, being able to attain a restraining order was essential to ensuring my safety and that of my son. If I had just filed for divorce, which can sometimes take months, my son and I would have had no protections. With the restraining order, my abuser faced immediate consequences when he broke the rules. I believe this was a wake-up call, and he left me alone afterwards. I was able to safely negotiate a divorce, the violence ended, and I became the primary parent of my son. For these reasons, I oppose both HB 494 and HB 495. I strongly urge the committee to vote ITL on both of these bills and ensure that domestic violence victims are able to access all the tools available to them when going through divorce or parenting cases. Thank you so much for hearing my testimony. I'm going to defer any questions to Pamela from the New Hampshire Coalition Against Domestic and Sexual Violence. Thank you.
Thank you very much for your testimony, Representative Toll. We'll hear from the last person who has their hand raised, Margaret.
All right, yes, Representative Perez.
Okay. Representative Perez.
Good afternoon.
Good afternoon.
Good afternoon, members of the committee. My name is Maria Perez. I'm a state representative for District 23, and I'm here testifying in opposition of HB 494. I'm speaking as a survivor of domestic violence, an immigrant who is very scared to speak up when I was going through domestic violence. And it is difficult when you're talking about someone scare you and like you and try to like keep you quiet when you're going through domestic violence, and they try to tell you that they're going to take you immigration status and they're going to take your kids away and you're not going to be able to see your kids. I went through that situation, and I believe this bill will make it really difficult, especially for people like I say myself. I've been here 23 years. I'm probably US citizens, but to be honest, there's a lot of victims like myself that either the language barrier, and then we have to find ways to get a translation, and then we have to wait to get protection orders. I believe this bill will make it so difficult for us to get any protection.
Thank you very much for your testimony this afternoon, Representative Perez. Are there any questions from the committee? Okay, seeing none. Thank you, Representative Perez. Okay, Margaret, is there anyone else?
There are no other hand. Oh, we have Jay Markle.
Okay, let's hear from Attorney Markle for the last time.
Yes, thank you again, Madam Chair. Basically, I'm hearing a repetition of the same arguments, okay? Now, first, let's be very clear. This has absolutely nothing to do with domestic violence, harassment, or any other form of abuse. I've heard everything I have heard, I respectfully submit, by a lot of people who are well-intentioned, is frankly not on point. Okay, this has nothing to do with RSA 173B. It has nothing to do with blocking civil restraining orders. However, the problems in the statute are as just. Courts frequently just take that to mean anything they want it to mean, number one. Number two, while I anticipate the First Amendment is going to be a very commonplace issue here, nevertheless, I was confronted outside of the restraining order context with, oddly enough, an Eighth Amendment issue. Okay, and I had to point it out to the court. And I've included that in my handout. Court basically got rid of the order when they found out they were charged, they were using alimony to they were using the man's conviction for a crime to basically take all the money he had. And pointed out to the court a recent United States Supreme Court decision, okay, which incorporated the Eighth Amendment's proscription against excessive fines, okay, and made it binding on the states, as well as the applicable New Hampshire statute. The point here is simple, okay? Any person claiming abuse is going to get the protection that they want. Absolutely. It specifically exempts RSA 173B. All it does is in not only, and the reason why it's in the parenting statute and the reason why it's in the divorce statute is because they both should be treated equally when you have people who come to court. So in other words, you wouldn't want somebody coming to court and saying, well, guess what? This is a parenting case and that statute doesn't apply. And since you have two sets of statutes, RSA 458, and you also have RSA 461A, that have basically congruent relief on congruent terms, unfortunately, you must produce two different statutes to address them. And that's an unfortunate reality. More to the point, I heard somebody say earlier that non-disparagement clauses create a problem. Actually, no, they don't. In a parenting context, a non-disparagement clause, which exists in a parenting plan, which says no parent can disparage the other parent in the child's presence. Now, that's going to withstand strict scrutiny. And the reason is because, number one, children can be damaged by what they hear a parent say. So in other words, you're going to say, and therefore, protecting the well-being of a child is a compelling government interest or a compelling government objective. Now, if you look at the parenting plan with the non-disparagement clause, it says you're not allowed to do it. And the reason why is that so the non-disparagement serves the compelling government objective or government interest, number one. Number two is that it is narrowly tailored to promote that government interest. And three, there is no less restrictive means to get to that interest. So that's a constitutional issue. It sits right there in the middle of the parenting plan, and that protects it. That's a legitimate government objective. Not legitimate, it's a compelling government objective. Now look at the shock case I sent down to you. You're going to see that whatever this guy said about his ex-wife was not said in front of the children and not said someplace else. And the SJC correctly got to where we were. And frankly, I'm very concerned about all the opposition I hear to this bill and its companion bill as being about domestic violence and harassment. I'm sorry, it's not. You're going to get your order. You're going to get your order. Okay, if you're a victim, you're going to get your order. This doesn't make it harder to get your order. All it says is, Mr. Judicial Officer or Ms. Judicial Officer, if you're going to do something which is going to infringe on an enumerated right, tell us why it is that you have to do it and why there's no less effective way of doing it. You still are protected from abuse. You are still, if you're a defendant, you're not allowed to harass anybody. You're not allowed to show up at their work. You're not allowed to stalk them. You're not allowed to say bad things to them, okay? If you've got that, and all you have to do is, and it's right there in shock, okay? Just read it. I didn't make this up, okay? This is our Constitution. It's a breathing document. I mean, I'm happy to entertain any questions that this committee may have before it makes an executive decision on these bills. I respect the legitimate interests of domestic violence victims. I respect the legitimate interests of people who are subject, who need a harassment prevention order. But that's not what this legislation does. It doesn't affect it. Doesn't even make it any harder. Okay? If a court says, I'm doing this, okay, here's the compelling, okay, court's analysis is real simple. I'm doing this and it infringes on the bump right under the federal or state constitution, or to the extent that it does infringe, okay, I make the following findings. A, this is a compelling government interest. B, this is narrowly tailored to achieve that compelling government interest. And C, there is no less restrictive way of doing it. That's right out of the constitutional law hornbooks. I'll take any questions.
Okay, thank you very much for your testimony, Mr. Markell. Are there any questions from the committee? Okay, seeing none, thank you very much.
Okay, thank you.
Margaret, anyone else?
We do not have any other hands raised.
Okay, terrific. I am going to go ahead and close the public hearing on House Bill 494. Okay, those are all the bills that we have scheduled for this afternoon. I would like to thank the committee. We are outside our normal block of time, which is tomorrow afternoon. So I will see all of you tomorrow afternoon. Can I get a motion to adjourn for the day? Moved by Senator Gannon. Is there a second?
Second that motion.
Oh, you beat Senator Khan to it, Senator French. So we have a motion to adjourn, seconded by Senator Gannon, moved by Senator Gannon, seconded by Senator French. I will call the roll. Senator Khan,
Yes.
Senator French,
Yes.
Senator Whitley,
Yes.
Senator Gannon,
Yes.
and Senator Carson. Yes. We are adjourned. Thank you all very much. And many thanks to Jenny and to Margaret for their work this afternoon.
Unbelievable.
I know, we couldn't do it without them. So thank you all.